Okay, let's think about this for a second. Imagine the police search your home, but they don't have a warrant, and they find some kind of evidence. Now, you know you're protected by the Constitution, right? But what does that protection actually mean when you're standing in a courtroom? Let's dive in.
It's a really fundamental promise of the Bill of Rights, but for the longest time there was this huge problem. Nobody was quite sure how to enforce it. The right was there, on paper, but in the real world, evidence that was gathered by totally ignoring the Constitution could still be used to convict somebody.
And you know, Justice Oliver Wendell Holmes just hit the nail on the head here. He said that without a remedy, a way to actually fix the wrongdoing, a right is just an empty promise. It's a beautifully written sentence, sure, but with absolutely no real-world power.
So, to give the Fourth Amendment some actual teeth, the Supreme Court came up with a pretty powerful and, yeah, a pretty controversial solution.
Here's the core idea. If the police break the constitutional rules to get evidence, that evidence gets excluded. It gets thrown right out of the trial. Now, what's really important to know is that this is a judicially created rule. I mean, you're not going to find it written down in the Constitution itself. It's the consequence the courts created to make the actually matter. But this rule didn't just pop up out of nowhere. Its evolution was, well, it was a slow burn. It all started back in 1914, but only for federal cases. For decades after that, it didn't apply to your local or state police at all. That all changed in 1961 with the huge landmark case Mapp v. Ohio, which finally made the exclusionary rule the law of the land for every level of government. Okay, so that brings up another question, right? What if some illegally obtained evidence doesn't just stand on its own? What if it leads the police to find other evidence? The courts came up with this really powerful metaphor to deal with this exact situation. So, the initial illegal act, that unconstitutional search, that's the poisonous tree. And any evidence that grows from that first mistake, well, that's the forbidden fruit. It's tainted too, and that means it also gets excluded from trial. But you know, the legal world, just like the real world, is almost never that simple. The courts realized that these rules can be a little rigid, so they've carved out some pretty major exceptions over the years. So the first big one deals with honest mistakes. I mean, what if the police really thought they were following the rules? This is called the good faith exception. If officers rely on a search warrant that they reasonably believe is valid, but it turns out later there was some kind of technical flaw, the evidence they find might actually still be allowed in court. The idea here is that the rule is supposed to deter police misconduct, not punish honest human error.
And that forbidden fruit idea, it has its own set of exceptions too. And they're all based on this central idea of breaking the chain of illegality. For example, under inevitable discovery, a court will ask, hey, would the police have found this evidence legally anyway? If the answer is yes, it might be admitted. The same goes if the evidence was also discovered through a totally separate, independent source, or if so much time has passed and so many other things have happened that the taint of that original mistake has basically faded away.
So you might be wondering, is throwing out evidence the only way to hold police accountable when they violate someone's rights? Not at all. There are actually other remedies available. Yeah, beyond just excluding evidence, there's a whole other toolbox. An individual can file a civil lawsuit against the officers and ask for money for the damages they caused. In really serious cases, officers themselves can even face criminal prosecution. And, on top of that, a lot of police departments have their own internal review processes, sometimes working alongside civilian review boards, which are designed to add a layer of external oversight. All of these rules and all these remedies really bring us to the core tension, the push and pull at the heart of this entire topic. It's a constant balancing act between two really important societal goals. So when it comes right down to it, this whole debate is about trying to strike a very difficult balance. On one hand, you have the exclusionary rule, which is one of our strongest tools for protecting constitutional rights and making sure police don't overstep their bounds. But on the other hand, critics will argue that it can come at a really high social cost, sometimes allowing someone who is clearly guilty to walk free just because of a procedural mistake. And that leaves us with this final, and I think pretty provocative question. There are no easy answers here. It's a continuous debate in American law. How do we strike that perfect balance between protecting the rights that truly define us and enforcing the laws that are meant to keep us safe?